is 10:40. We apologize for the delay. I call to order this special meeting of the Village of Tuxedo Park Board of Trustees. For the first item, we'll call the roll. Clerk not being present. Trustee Shaw.
Present.
Trustee Brooke.
Present on Zoom.
Trustee Scherer.
Present via Zoom.
Deputy Mayor Lindsay.
Present.
And the mayor is present. This meeting is called for the purpose of the board acting as the FOIL appeal officer. We have with us the village attorney, Brian Stolar. Brian, I'll turn this over to you for the initial explanation of the purpose of this meeting and the actions the board may or may not take with respect to the meeting.
Very simply, under the Freedom of Information Law, you have a records access officer and a records appeal officer. Your code provides that the records access officer is one of a number of people, including the village clerk. It does not make any reference to who the records appeal officer is. So under statute, state statute, the Board of Trustees serves as the records appeal officer. In this instance, you have received, or at least initially, an application was made for documents, specifically legal opinions, memoranda, or other kind of legal advice relating to the authority, relating to any advice that we have may have provided regarding the authority of the board members to participate remotely, and those that participate remotely vote at a meeting. The submission was made to the village clerk. The village clerk denied the request under a FOIL. And as a result of the denial, the applicant has an opportunity to appeal to the appeals officer, you as a board, and they have done so. That appeal was submitted at 4:40 p.m., 9 business days ago, or 10 business days ago, but because the village hall closes at 4 p.m., technically it's considered filed the following day. So now it's in your hands, and you have to get together to make a decision as to whether the legal advice that was provided is disclosable under the Freedom of Information Law. We've provided the board with advice regarding whether or not that is permitted. That, again, comes under the grounds of legal advice, and it's not something, as we have, as Ms. Doherty has advised them, and as I recommend the board make a decision, that legal advice is protected. It's not subject to disclosure. There's a specific provision both in the CPLR and in the Public Officers Law that protects that information, and there's no requirement that you provide it under the Freedom of Information Law. So based on that, based on the request, the specific request for legal advice, your authority as a record appeal officer, I would recommend that the board adopt a decision further denying the request on the grounds that I laid out to the board.
Well, thank you, Brian. So it appears that the requester, Mr. Sarcone, is seeking legal memoranda with respect to opinions of the village attorney and or any attorneys within his office regarding whether or not trustees or the mayor may participate remotely in a meeting of the Board of Trustees and may cast their votes remotely. That obviously comes under the rubric of a legal opinion, and any memoranda, writing, text messages, any documents at all relating to the attorney's opinion with regard to whether members of the Board of Trustees may vote remotely and participate in meetings remotely is within the exception of the FOIL law and does not have to be disclosed to any requester. Essentially, that's my interpretation. Would you agree with that, Brian?
100%. You know, it's specifically attorney-client advice given in the context of the attorney-client relationship is specifically excluded under state law.
Any of the trustees or the deputy mayor have anything additional to add on this particular point?
No.
Okay. Then do we make this decision by resolution, Brian?
By simple motion, I can give you the text for it. We can actually, you know what? Let's call it a resolution.
Okay.
All right. So essentially what it is, whereas an application was made by John Sarcone for specific information regarding legal advice given by the village attorney to, hold on one second, sorry, I'm working from home and my dog who's handicapped has, wants some food and he's letting me know. And if I don't give it to him, you're gonna hear him barking really loudly in about a minute. So give me about 10 seconds.
Sure.
So I have a question, which is, this is a Sarcone motion. Sarcone has no standing. Who is he representing?
Well,
Claudio.
He doesn't have,
Claudio.
he's copied Claudio Guarzoni on the emails in his submission, but he doesn't have to disclose who it is he's representing.
Yeah, he doesn't-
Okay,
But this is a general motion to basically say we're not going to divulge any information related to legal opinions. I think it's broader than just the Sarcone request. I think it's coming up because of Sarcone. Is that not right, Brian?
There are two, if you look at it, you know, you can look at it in a generic way like that and
Yep.
in a specific way, because there's a specific application now appealing the underlying determination made by Ms. Doherty. You have an obligation as the appeals officer to make a determination. So
I
you
see.
have to make that determination specific to this request. In general, though, you know, as you suggest, it's legal advice and it should be made known that any legal advice is not subject to disclosure if given in the context of the attorney-client relationship.
However, should a subsequent request be made, similar to the one that's being made for legal memoranda, we would have to evaluate that separately. Each and every FOIL request has to be, a determination has to be made on its own merits. Is that correct?
Correct.
Even if this general rule is applies, Brian?
Correct. And
Seems very, very inefficient.
Agreed, but it's one of the reasons why we also suggest that going forward, rather than serving as a board or the board serving as the appeal officer, that you designate a particular individual to serve in that
Right.
capacity so it can be done administratively on paper.
So let's talk about that because and we can get to, we need to vote at some point, but let's talk about that because I was obviously in support of the mayor playing that role. I view it as an efficiency issue more than anything else. But Brian, maybe you can lay out the pros and cons, and maybe just to catastrophize a situation. Let's say, and Mayor, don't take this the wrong way, because it's really just intended as an example. We have a rogue officer, right, that is not in sync with the rest of the board and is making decisions that ultimately are inconsistent with the wishes of the rest of the board. What, if any, remedy does the board have in that situation?
In that situation, none, essentially. You wouldn't be an aggrieved party. You're not the
Yep.
one making the appeal. You're not a board member, so you don't have authority to make the determination. It's that person's determination that will be the determination at the end of the day. You know, if somebody who makes the
Hold on.
request,
Pause. You said you're not a board member. We are board members. So
you're not, as a board member, you're not, you don't get any, you don't become an aggrieved party as a board member. Sorry if I said that.
right. Okay.
So as a, you're not as a board member. Sorry. So the the only person who has the right to challenge it would be the person who makes the appeal. That person is an aggrieved party, and if they appeal to the Supreme Court, it has to be dealt with. Of course, in the interim, if it's a decision that the board thinks something else should be done because the board would authorize the expenditure to defend, we can have that conversation at that point. And if it's appropriate to have settlement discussions to try to resolve the issue and convey information that may otherwise be permitted to be disclosed, then yeah, by all means, we could do that in the interim. So that's certainly still out there if somebody commences litigation.
Okay, so let's take that extreme example. FOIL request made. The officer who has sole power at that point in time grants the request. The majority of the board disagrees with that. I just want to be clear in that instance, the information would be provided to the requestor. And I guess what you're saying is if as a result of that request being made, there's resultant litigation. I just want to understand, like, what you just said, where you got to the piece where there's potential litigation and the board then could make a determination about the path forward. Explain. I just want to be very clear about this, Brian.
Josh, the litigation only takes place if there's a denial by the appeal officer.
Right. So if it was
Obviously,
granted,
yeah,
I see. I understand.
yeah.
I understand. So yeah, that makes sense. Okay,
If the
I
rogue
understand.
appeal officer, if the rogue appeal officer, whoever that may be,
Right.
grants the appeal and the documentation is provided, the board of trustees may be disappointed, but the board of trustees has no standing to challenge that decision.
Okay, I understand. All right,
Josh,
so
are you
yep.
saying that as a result of the information being given to the applicant, that then that applicant could sue the board? Or,
no, I was just trying to
the
understand what Brian
action?
said, and the mayor explained it to me. The litigation would occur if the officer denied the request, and as a result, the requestor, the person who filed the FOIL request, initiated litigation. If the board had been actually disagreed with the officer's determination that the information should be designed, the natural outcome of that situation would be a settlement where the board would say, hold on, actually, majority of the board actually believes that you should have the information, and we'd have the conversation at that point. But if the rogue officer grants the information to the person who filed the FOIL request, the rest of the rest of the board disagrees with that, there's really no remedy, as I understand it. Now, there are consequences, right? That rogue officer has to continue to operate on a board, and depending on how egregious the decision was, it could hurt their influence and ability to be effective on the board. So, I mean, there's always consequences to actions, but there wouldn't be any immediate remedy that there wouldn't be any remedy that the board would have.
Not in that case, but the board, if they felt so aggrieved, they could change the records access officer. If they felt that
that's true, but you couldn't. I agree with that, John. But you couldn't unwind
No, you're
the
right.
decision that had been made.
Correct.
Would it be more
So-
efficient then for the board to continue as the appeal?
No, I'm personally in support of providing the mayor. I just wanted to make sure I understood. I think as a practical matter, it's not practical or in any individual's interest to consistently and actively go against the board's wishes. I think this is purely an efficiency issue, my view. And
let me make one statement, okay?
Okay.
Which is this decision by the appeal officer is not made in a vacuum. The appeal officer has the option of speaking to all the other members of the board. What do you think, guys? Ultimately, administratively, the appeal officer has to sign off on the decision. But if you're worried about me as the mayor making these decisions independent of any input from the trustees and the deputy mayor, I think it's a concern that I can tell you you should not have.
Right.
I don't operate that way. But ultimately, the decision will have to be my decision after consultation with members of the Board of Trustees, the other members. If you want to designate somebody else, that's fine too. But I think for the purpose of one, saving on attorney's fees by not utilizing or designating the village attorney. Two, not having us get together at odd hours to make these determinations separate and apart from our duties as regular members of the board. I think we should have a FOIL appeal officer, and that FOIL appeal officer should be an individual who's on the Board of Trustees. It doesn't really matter.
Agreed.
Who it is.
I agree. And again, I think I may have been the only one to respond to the mayor last week. I said I was fine with the mayor being the FOIL records officer or whatever the title is, and I haven't changed my mind. I'm still supportive of that.
Okay, and anybody else want to address the issue before we move forward on the first resolution?
No, I think we move forward.
Yeah, no, I'm okay moving forward as long as the rest of the board is aware of it, that the decision isn't just made without.
Consultation?
Yeah, just saying, and if you have any comments, please forward them, and if no one has any comments, then fine, just move ahead. But as
Okay.
long as all the board members are aware.
Yeah,
before the
that's
decision is made.
agreeable to me if I'm designated as the FOIL appeal officer to consult with the other members of the board to reach some sort of consensus before I render a decision. Is that permissible, Brian?
By all means.
Okay, so there we have it. So can you recite the resolution on this particular application, please?
Whereas on February 22nd, John Sarcone submitted to the Records Access Officer a request pursuant to FOIL for any legal opinion, memorandum, letter, email, or text to any board member or mayor that provides the legal basis that virtual voting by a member of the Board of Trustees is legal. And whereas the village clerk responded on February 27th, advising that the request is denied as the information is exempt from disclosure under FOIL pursuant to Public Officers Law 87 sub 2 sub A. And whereas the denial also informed the applicant of the opportunity to appeal, and whereas by email dated February 27th at 4:40 p.m. after the village hall closed, the requestor submitted an appeal, and whereas the board serves as the records appeal officer, and this, as of today, March 12th, the board makes the following determination. One, the request by Mr. Sarcone is a request for a legal opinion. Two, the information requested, to the extent given as a legal opinion by the village attorney, was prepared and provided in conjunction with the attorney-client relationship between the village attorney and Board of Trustees. Three, in accordance with the Public Officers Law and the Civil Practice Law and Rules, the advice is not subject to disclosure. And next number, the board determines that as a result, the appeal is denied and no information regarding any legal opinion is to be provided to the requestor.
Okay, I'll move the resolution. Is there a second?
Second.
Second.
Second by Trustee Shaw. All in favor?
Aye.
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 Unanimous 5-0.
All right, so the second one, if you're doing a second one, would be for an appointment going forward of a records appeal officer, at least for the balance of the official village year. So anybody can make the motion to designate.
Yeah, I'll make the motion that the mayor be designated as the FOIL appeal officer for the balance of the village year ending in early July of this.
May 31.
Is it
May 31.
May 31?
No, it's the first Monday in July.
Yeah,
Oh, I
Yeah.
see, for the
Yeah, yeah,
reorg meeting,
yeah,
okay, okay. sorry.
and ending the first Monday, that the mayor be appointed the FOIL appeal officer, ending for the village year, ending the first Monday in July. Is there a second?
I'll second.
Seconded by the deputy mayor. All in favor?
Aye.
Aye,
And just as long as, do we have to put it there that the mayor will, or the officer will share with the board members?
I don't
as
think
part of
that's
that, or no?
appropriate in the motion. I've told you.
I don't know
Yeah, I've
if
told you
it's-
this is
it's
the way
part of it,
this
yeah.
is the way I operate, so. The motion should simply be an appointment, for FOIL officer. I've represented on the record that I intend to consult with all the trustees and the deputy mayor.
I'm fine with the motion.
All in favor?
Aye.
Aye. Paul?
You're on
Paul?
mute, Paul.
aye. I'm
Aye.
on,
Okay,
aye,
all right. 5-0.
unanimous.
5-0.
Okay.
That being said, our business is concluded. I move
Great.
that this special meeting be adjourned. Second by trustee Shaw. All in favor?
Aye.
Aye.
Aye.